Very warm welcome, everyone. We've gotten together today to discuss this very important issue. And I think more than any other time in history, the last couple of years have taught us that no matter what we plan, no matter what we prepare for, there's always an imponderable that may upset the schemes that we make. As one of my favorite authors, Steinbach, says, the most well laid out schemes of mice and men often go awry. So the discussion today is going to be about the ways and means in which businesses can prepare for stress and distress better. What are the legal recourses available to minimize or mitigate the effects of distress? We've got a stellar panel today, which needs absolutely no introduction. But I'll just, in the interest of time, and time is really of the essence here, I'll not take much time. I'll just straight away, go to, who do I start with? Maybe I'll start with you, Manisha, and just request you to weigh in on the legal recourses available to a business in distress, or how the legal regime helps a business in distress. And the distress may be financial, the distress may be because of any other dispute, for instance, a shareholders disputes. So where do we stand on that in terms of law? So let me just throw that to you.
Thank you, Bharat. To try to start with what causes distress in companies, it's a very business-oriented question, a very commercial outlook to it. It starts with anything as simple as, of course, the whole debt exposure of the companies. It starts with margins being changed. It starts with variables and fixed assets, fixed incomes and fixed values being changed. It starts with something as simple as employee being redundant or not being productive. And it leads to a lot of ripples in the company, eventually leading to a distress situation. COVID has been a distress situation for many companies, which have been great all this while. And of course, one of the biggest which we usually deal with is disputes in a company also lead into a serious distress. I'll talk about what a shareholders dispute can do to an entity. From my experience before the NCLT in the Companies Act, I have seen small companies to huge corporations incur millions in legal fees while fighting shareholders dispute under 241, 242, which was 397, 398 earlier. It is a mechanism by which any issues in the company should have been solved, whereas any status quo which is granted to these companies eventually lead to a distress situation where I've seen AGMs not being held, EGMs not being allowed, resolutions passed in EGMs, which is a very corporate democratic way of going about an entity, not being allowed either. I have seen boards not functioning. Over the years, yes, they have watered down these status quo orders which they passed. There have been times where they're completely denied, but a appellate tribunal or the High Court in previous days or the Supreme Court even has granted those reliefs, resulting in distress situations for companies. Apart from that, the debt exposure takes us to the beautiful IBC that it is today. Over the years, in the last 4 or 5 years, you've seen how many changes have been brought into the law, which automatically shows where it started, what it was meant to be. Maybe we could have done a much better job of drafting it in the first place. Furthermore, I think there can be mechanisms outside of litigation or the codes, which can lead us to try to get companies out of distress. There could be restructuring of the debt under the Companies Act. It could be a restructuring with the debtors, with the creditors, just as managing your assets. You could be selling your assets. It could be itemized selling. It could be slump sale. It could be a joint venture. You could actually talk it out with your creditors. They could even come in. That many times when banks come in onto the boards to ensure that the stressed companies are actually working the way they're supposed to be working. All these mechanisms don't really lead to a court or a code, but even are basically corporate transactions, negotiations which are taking place to ensure that the companies are out of debt and stressed, out of distress.
Thank you, Manisha. You packed a lot in there, and there's so much that I want to double click on and pick your brain some more on that. And I'll do come back to that. But let me take this to Ramanuj. Before we, of course, address the elephant in the room, the IBC and how it's sort of help matters or not help matters, let me ask you a question on what, apart from IBC, more often than not, we also forget that the Companies Act still also provides for ways and means in which the distress situation can be made better, or there is a remedy, or there is an outlet there. If I could request you to, spend a couple of minutes on those, if you may.
Sure. Thanks, Bharat. Good afternoon, everyone. Pleasure to be here. So I think, before we talk about what the company should do or would do in distress, it's also important to recognize what causes distress. Now, what we have seen over the last few years, especially with the introduction of IBC and even before that, that large part of distress in the economy has either been caused by over-leveraging or taking too much of debt when the businesses are not able to sustain that much debt. Or another major reason has been the governmental policies, the government contracts or the PPP contracts, mostly in the infrastructure sector, where the contracts haven't factored in sufficient risk allocation between the private sector and the public sector, or the regulatory mechanisms to deal with contractual disputes or contractual failures haven't been robust enough to provide adequate and timely support measures to the sector or to the participants which have caused distress. Now, if we look at, just to answer Bharat's question too, if we look at measures outside IBC in terms of how the distress can be alleviated or addressed, essentially we have three frameworks or mechanisms where the distress can be dealt with. One is sections 230 to 232 of the Companies Act, which deals with schemes of amalgamation, reconstruction, or merger, popularly known as sort of amalgamation merger scheme. Now, this is relatively less used for addressing distress resolutions, but it's quite an important and an effective tool outside the IBC framework, because it allows complete flexibility to the companies concerned, the promoters and the shareholders, as well as the lenders, to design a scheme which can address the immediate as well as the medium term and the long term causes of distress and how that can be addressed through a proper legal framework. And that, of course, needs to be approved by the NCLT and requires the sufficient support of the creditors and the shareholders, but need not necessarily follow the rigors of IBC. And it can still provide an effective mechanism to address distress situations. And a current example before us where the section 230 to 232 has been employed is the resolution of IL&FS distress. The entire IL&FS resolution framework is being worked out under the aegis of the 230 to 232 of the Companies Act through the NCLT route. Another important framework for addressing distress is effectively provided by the RBI. Now, obviously, we need to remember that these are the RBI framework is primarily a tool in the hands of the creditors, because they are the ones who have to mostly bear the brunt of distress before the shareholders bear the losses. Now, under the RBI framework, there are two important elements. One is OTS, that is one-time settlements of the debt with the creditors. And the second is the debt restructuring. Now, debt restructuring can take multiple forms, but OTS itself provides a very powerful and important tool to address distress. And what we have seen in last few years is that OTS schemes are primarily being driven or funded by special situations funds, global distress funds, asset reconstruction companies, and private credit providers such as your Goldman Sachs and Morgan Stanleys of the world. where they bring in specialized expertise to deal with excess debt. They do necessary financial modeling to see how much debt a business can sustain. They bring in new funds, additional funds in a situation where no domestic lender would be willing to lend to that business or would be willing to fund that promoter. And they bring in a certain financial discipline, which we find that may not necessarily have been available before the distress was caused. Other than the OTS, you have the usual debt restructuring under RBI's June 2019 circular, where the restructuring can take multiple forms, including haircuts in the principal amount, conversion of part of the debt into equity, conversion of part of the debt into equity-like instruments, for example, CCPS or CCDs, and also in certain cases, promoters losing control of the company, where a new promoter is brought in by virtue of either reduction of the debt or by virtue of selling of the company by lenders invoking share pledge and transferring the control of the company to a new promoter who is considered more suited to manage the business and the restructured debt of the company. A third more important framework, which is also relatively less used, but more relevant and available in infrastructure contracts, is what is called substitution, or if we talk specifically of the road sector, it's called harmonious substitution. It's available under the concession contracts with NHAIs, where the existing promoters or the sponsors, if they can't manage the debt with the available cash flows of the projects, then there is a built-in framework under the concession agreements where the existing sponsors, with the consent and blessing of the NHAI and the lenders of the project, can bring in another sponsor or promoter who can take over the debt and take over the company, mostly a majority stake, release the existing sponsor from their obligations, including the guarantees, and take over the project, become the new sponsor, and manage and run the assets. So these are some of the important frameworks available outside the IBC where distress situations can be managed and addressed.
Thank you, Ramanuj, for that very effective and interesting summarization of the non-IBC frameworks. And but again, the discussion's not complete unless we do talk about IBC. And this is where I come to you, Niraj. And if you could just help us understand the broad framework, or how the IBC helps or doesn't help, and how does IBC look at businesses in distress, or how should businesses in distress rather should look at IBC to help them?
All right. So because IBC has been a game changer, I mean, the advent of IBC has a backdrop to it, where earlier you had structures like CDR, SDRs, which largely failed to actualize. So where IBC comes into, and where IBC is completely different, or a break from the past, is earlier CDR or SDR used to happen when the company was already in distress, the business already taken a downturn, and then out of sheer compulsion that the bankers used to sit together and allow this. Prior to that, if the company is healthy and the businessman or the promoter thinks that the company is actually going south, and he used to sit together with the bankers, in case of multi-party lending, it was very difficult even to make the bankers sit together and have a discussion on it. So where IBC is it should be seen as an opportunity by the promoters, is that it has a provision where in case the propaganda of the business itself believes that the company is not doing well, or the business, or there is a stress on the horizon, he can do some preparatory work towards it and actually make a filing for Section 10 application, where the company itself by voluntary action go to insolvency and try to do a course correction. Now this latitude was earlier completely absent. So this is something which ideally IBC should be seen as an opportunity by many new businesses and new promoters, rather than basically how the negative publicity it has got when it got introduced. So that is a big differentiator. And in case you are not delinquent otherwise, then even the whole negative publicity about Section 29A coming to picture, that you cannot bid for your company or you cannot provide a solution to your own company, all basically doesn't come into picture. So that is the big change.
That's very well said. Let me take this opportunity, and I'm going to come back to you on some of it if we have some time left. But let me bring you in, Pallavi here. You practiced very actively on this side, and in the last few years, we've seen some very big insolvency cases. If you could just take this opportunity to just talk about some of those, if you may, and what are the key takeaways from those for businesses in distress and for lawyers who practice in this area of law?
I don't know how much lawyers are going to benefit out of it, but I'm sure a lot of promoters would probably benefit out of it. Because I think I'll go with my favorite first, which is RCOM. I think clearly it was one of those CDMA versus GSM technology that they could not really get on to. And I think personally that, the launch of Geo was something which was more competitive, as a result of which we saw that RCOM faced insolvency proceedings. The second one I would say would be Jet Airways, which has been one of the biggest challenges that we are still facing, because it is an endless litigation which is going on and on. Even though we are seeing a lot of restructuring happening over there, I don't see too much of a resolution coming out of it. Then, of course, both the Bhushan's, Bhushan Steel and Bhushan Power, I think both of them have actually shown us that course correction is very difficult. And there is a lot of debt binging which is happening. So, you've got a debt, like Manisha just said, that the debt equity ratio is something that, is a big challenge that I think corporate world is not able to understand and figure out a solution to it. I mean, the kind of insolvencies that we've seen in recent past, the debt equity ratio is some 3:1. So if you've got 3 times debt as compared to the equity that you have just now, that in itself shows that you are in for a big challenge. As far as practicing litigating lawyers are concerned, I think for all of us, of course, it's a huge opportunity because we can all bill quite a bit. But if you look at it in terms of pre-existing disputes that you see in a lot of these cases, I think that is where our challenge is coming. Because we are not able to provide the solution that we would have wanted to. That's one. Secondly, with the resolution applicants who are coming in, I think they are not able to take the companies out. So many of them are just backing out in time. And for as litigating lawyers, I think that is one area where we find it difficult to, take it forward. The third most important problem I think that we are facing just now is with the operational creditors who've been filing Section 9 applications left, right, and center only to treat IBC as a debt recovery procedure. I think that's what's causing a lot of problem in the resurgent India that we are seeing just now. Post-lockdown period, I think that's become, despite the fact that the threshold has been increased, it is still a huge challenge that we see. I hope I'm well within my time. Yeah.
Thank you for that. What all of you say reminds me of what one of my favorite authors, Nicholas Taleb, says about things in general. He says there are 3 kinds of things or persons or institutions. There are ones which are fragile, which do not benefit from stress. There are ones which are robust, which deal with stress somewhat better, but still are susceptible to it or vulnerable to it. And there are things or structures or persons or institutions which are anti-fragile, which under stress or distress deal with it better and sort of come out even stronger and better. So I think in light of what you said, I think businesses can learn from all of this and not just be fragile or robust even, but also become anti-fragile and deal with this better and come out winning. I think we've got about 1 minute. Do you think, Ashima, I can have everyone say one last bit each, or should we close it here before you? Okay. Or questions from the audience, of course. Guys, it's been a long day, I think, and I blame it on the extraordinary clarity that you guys bring on the topic. So sounds great. If there are no questions, we'll bring it to a close. And
Hi.
Okay, yeah.
Hi, sir. My name is Akshay Sharma. So we are talking about IBC. We are talking about company laws. So basically, right now we have an example in front of us, which is the future retail. Everything has been tried and tested, be it arbitration, be it 232, failed, secured, creditors did not agree to it. RBI stress resolution also failed. Finally, the buck has stopped as the IBC, where there are various sections 7.5. Now, this is a brief background. In India, when we talk about businesses in distress, the zeal of the businessmen not to give away their business is basically troubling all these laws. What stopped Kishore Biyani 2 years back to file a section 10? Nobody can explain it. Today he has resigned. Similarly, if you see Ruiyas, the SR Steel case, they fought not once, twice, but thrice to get their company back, even themselves filing into insolvency. So we know we have a 29. We know we have a 29A, which says you cannot come back, but then there are ways, 12A, everything. So how to stop the zeal of an Indian businessman to even themselves realizing that your business is in distress, but to get it back?
Fantastic points. Anyone wants to meditate on that?
Maybe
Please go ahead.
Go ahead.
Okay. Yeah. So I will try to address that. Look, it's very easy for a human being to be attached to what he has created. So I don't see any, it's not very surprising that promoter of this company or whatever company that you named was basically attached to its baby and wanted to keep to hang on to it as long as that they can. And that is where basically the fault line comes in. You have to see the company as not your extension. It should not be seen as a family jewel where you can actually keep control of all your time. So you have to understand that this company is for example, a public listed company. You are anywhere in public domain, and you should be prepared to cede control as and when the situation arises. I will give you an example here. Prior to Byju's, all the edtech companies, largely business was B2B. You had a content, you used to go to schools, you used to sell it to schools, and that is how it reached to the students. Now complete disruptions happen. Basically, Byju comes in, it's B2C model now. So here, all the B2B players, all the edtech companies should have understood that, okay, this is a big disruptor. It will not allow them to continue historically how they have been doing business, and ideally should make amends. But you see that EduComp, etc., all these have actually either have been sold out or have been referred to insolvency. So that acumen as a businessman, when you have to call it a day for a particular business, that has to come in. And insolvency basically is a way to provide that panacea to them.
I have a slight different view when it comes to promoters being the cause all of insolvencies. They're not. It's not always that the promoters are causing the companies to go down the drain and for them to be pushed into insolvency, or for them not knowing what is going on in the company or how to get it out of distress. They very well know how to run their companies. Then they had brought it from 0 to 1,000, 10,000 crore company. It's the way the debt has also been given, which is blindly been given to people without actually checking the asset basis on it. There have been issues that as simple as steel becoming more expensive, Chinese steel being imported, government norms changing. All of these contribute into a reason of why a company might go into distress. To singularly say that the promoter should exit from the company is also not something that I stand by, at least under the present insolvency regime. I do think that promoters know how to run their company. If they're in default, if they've caused some issues, yes, there are laws and mechanisms to put that in place. But there are still promoters who could have run the companies, brought them out of distress and taken them forward, had the right mechanisms being given to them. They can't always be treated as the wrongdoers. That's my slight difference on the whole scenario of this.
May I just add, and this has got nothing to do with insolvency, but to the aspect of promoter, you might want to watch something which is called a Super Pumped, and that is about the founder of Uber. And it actually, there are 7 episodes of it where he shows how he's built it up, and then at the last moment when he's asked to step down as the CEO, I think that captures a lot about how a promoter actually works with the company. So that's just a suggestion.
Awesome. Fantastic. So thank you very much for this riveting discussion, and have a lovely evening ahead, all of you, and congratulations to the winners. While a failed business may not be a crime, and IBC may be there, I think they won't allow me to continue any further. So have a great evening, all of you. Bye-bye.